welcome back to Law and Crime Trial Network. I'm here with our guest, Mike Koribanics, and as well as a new guest. Have you been with us before?
Yes, I have.
Oh,
Not in the studio, though. First time in the studio.
All right, first time in the studio.
I'm David Schoen.
David Schoen, I apologize for that, David. So we still got a couple cases going on. We have the Nelson case, we're still waiting on the sentencing. We also have the Kuhn case. Now, the Kuhn case is live. We are not going to be covering it right now on the Law and Crime Trial Network, but you can go and watch it online. We also have the Rosenbaum case. Now, if you're coming to us for the first time, where have you been? The Rosenbaum case is quite interesting. We have both Jennifer and Joseph Rosenbaum, who are accused of killing their 2-year-old foster child. Now, we're going to go to the court to see who's on the stand and testifying today. So there you have the witness just stepping off the stand. It's my understanding that this witness took care of the children in the interim while the mother couldn't take care of them and before they went to the Rosenbaum. Now, I have my ideas and my theories of why that might be, but David, what do you think as to the quality of this witness and also the purpose of the witness here?
Right. Well, I haven't heard much from the witness yet. As I think you mentioned, we were talking earlier, one would think the likely purpose would be to rule out all possibilities of earlier trauma. We haven't heard the medical evidence yet, so we don't know what. I know that there is a report by a medical witness that some of the injuries were close in time to the death and all that, so that would sort of rule out the previous burn. But I'm sure they want to close all of the loopholes, as you so wisely said earlier.
Yeah, and Mike, as a defense attorney, you're pointing the fingers in all different directions when you look at these injuries. Either the injuries came from trying to resuscitate the baby from this chicken bone or chicken tender or whatever it is now, maybe a chicken finger down the line, or maybe that the child was in a different care and that's why the injuries. Is this, as David is saying, is this kind of closing up all those ends?
I think as a defense attorney, you're a little leery of this. You got to be careful of these kind of witnesses because I believe, and there's all different theories when you're defending someone, I believe you have to maintain credibility with the jury. And if you start pointing the finger in too many directions, when you basically open up to a very solid defense theory where you're saying, here's what happened, as opposed to we're creating reasonable doubt. You got to be very careful with a witness like this.
Yeah. Kind of sounds like the Nelson defense, another case we've been looking at where he's blaming the probation officer and his mother and his sister and everyone else. But we're going to continue with this trial and more after this break. So here we are, the witness is taking this, just stepped off of the stand, and during the break, my guest and I are talking about something and we're a little perplexed. Now, we know that Corinne Mull is the appointed defense attorney. She's what many people call a public defender, as am I. And what's confusing to my guests and I are, why is there one lawyer representing both defendants? Now, Mike, I'm going to go to you first because David, I know he's got the lion's share of his ideas here. Does this make sense to you? Does this not work? Did someone drop the ball, or is this just no big deal?
I don't even think anybody here knows where the ball is, quite frankly, because I can't see how this is occurring. You have a murder case where people are looking at significant time and have antagonistic defenses. They should each be entitled to their own lawyer. In New Jersey, this would happen, and in the federal courts, this would never happen. It would be something a judge said you can't waive. It's too critical. You each need someone looking out for your own interest.
So David, Mike brings up the buzzword, antagonistic defense. If you and I are both in a car, there's a gun in the car, and I'm saying, hey, it's David's gun, and you're saying it's Brian's gun, how can you have one lawyer represent you with both defenses?
Right, and that's probably the #1 reversible error for conflict issues. I think Mike's 100% right, and you're 100% right, Brian. It's impossible to understand how this happened. They do have problems with funding the indigent defense system in Georgia, but this is no excuse. And the prosecutor also has an independent duty to the integrity of the process to make sure this didn't happen, and he or she has just put an appellate issue into the case. But what's most difficult to believe is how the judge possibly let this happen. At the end of the day, the judge is in charge independently of maintaining the integrity of the process. We all have a stake in that, frankly, because if this kind of thing happens in any case, we all lose. You pointed out, Brian, correctly earlier, just one basic example of this is the husband is charged with second-degree murder because he left the child with the wife, allegedly knowing that the wife was an abuser. So as you pointed out earlier, if the husband's defense likely could be, his wife may have been an abuser, but he knew nothing about it. And in fact, she did a lot of things behind his back he didn't know anything about. This lawyer ethically can't raise that defense. That would be, as Mike said, antagonistic to the wife's defense in the case. What are you, crazy? I'm not an abuser.
Yeah, and just for our audience, I know that we are very well versed in this, but think about it this way. Think about if you're trying to point the finger at someone else and they're trying to point the finger at you, if your lawyer's interest is with you 100%, you can't split that. The best thing I can think about is a parent trying to decide an argument between two children. As much as the parent might love one or the other child, there's no way they can say, my interest is fully vested in this person or this person. And that's why, as our guest said, the judge should have separated this. And it's very perplexing as to why it wouldn't. I think that Joseph Rosenbaum might have the greatest of arguments at appeal, because he's, like as you said, David, he's pointing the finger at the wife, in part and parcel at least, and he's lost that defense completely, and so he's kind of at the whim of whatever the jury might give. Do you think there's any way of maybe cleaning this up? I mean, I have no idea. I mean, it seems like the bell's already rung, but David, is there any way of clearing this up down the road?
I don't think so, because the problem here is in the potential defenses. It's not just in what the lawyer has done, it's what the lawyer wasn't ethically permitted to do. And so all you need is a lawyer afterwards to say, that was it was an alternative defense strategy that this lawyer was prohibited from taking, frankly. And so, as Mike said earlier, the stakes are pretty high here. This goes both to Joseph's potential conviction and to sentence in the case. He may, wanted to point the wife, maybe his best defense, point the finger at the wife in all circumstances, even if he were to be found guilty, that the wife abused him also. I don't know.
Ineffective assistance of counsel, and then add on to that.
Yeah, absolutely. But maybe there's a bigger strategy, David and Brian, that we don't know about, because I could see this just turning into a explosion. Suppose the husband says, I want to take the stand, and I'm going to tell you something. She was beating that baby. She knew that I was doing something else. She was blackmailing me. That's why I didn't do anything. Now, all of a sudden, this case is gone for nothing and a mistrial be declared. The only way you can fix this is to just say, it's done, get this jury out here, let's start again.
Yeah.
And I think they'll spend a lot more money than they would have spent on a public defender to try the case correctly the first time.
Yeah, or you hire one of these gentlemen and they come and they take one of the cases. I'm sure that David would love to. I heard you're not too far from this county. But we're going to figure out what's going on in this case and others after this break. So welcome back. That is the prosecutor's opening statement. Now, we were talking about it both stylistically and the information. What I would say is she was stuck on 10. There was no real modulation as to where she was going. And Mike, you were saying, where does she go from here? Like, if she's always at this level, is there any more to go up?
I think it's see, as a prosecutor, I think you're a little more constrained. And when I was a prosecutor, when I had hair, I always believed that you have to be very careful in your openings, because you don't have the freedom in your arguments that the defense does. You really, and you're meeting those 14 jurors, 12 who's going to decide the fate for the first time, so you wouldn't run into a party yelling and screaming. Now, maybe it works sometimes, but I think you've got to build that credibility. Where you want to be at a 10 and stuck at 10 is in your summation. After they know you, they understand you, they see the theory of your case. But listen, this may work very well for her. I mean, passion goes a long way.
Now, David, you said that she's got the righteousness on her side in the sense that there's a dead baby here.
Yeah.
Like you've got, and I agree with you, you've got to have that passion. Do you think that this the passion and also the information is going to be conveyed well enough to the jury to kind of keep them awake this whole trial?
I think so. You both make the technical points that are, of course, absolutely right. First of all, this may be her only gear. It may be stylistic with her, but I do think it's one case in which she can possibly afford to do this, because she's setting them up with this righteous indignation from the start and hopes it carries through. Nobody could, in a monotone, talk about a baby who was killed by being beaten, 2-year-old baby by being beaten.
Absolutely. And stylistically, because this is my fear, and we're going to go to another clip about with more of the opening statement. Some of us don't even know what she was saying. For the most part, we're here talking about stylistic and how she was yelling and this and that. So the fear for the prosecution is, are they going to remember what she said or just remember how she said it? And I think that might be a difficulty for her. But let's take a look about that after we look at this clip of more of the opening statement. So there you have the opening statement. And at least for me, I heard a little bit of a difference in the modulation, which actually made it easier for me to hear and compare and contrast what she's saying. And it was interesting, Mike, that some of it came during the injuries, talking about the rupture of the liver being pressed so hard against the body, and which could be consistent with CPR and other injuries.
Before I say something, I want to just make clear, that was her opening statement, correct?
Correct.
Because I don't know about you guys, but I just heard a mistrial motion. Because she was talking about the defense, what they're coming forth with. Under the Fifth Amendment, the defense is under no obligation to come forth with any defense. The burden is on the prosecution to come forth with proofs. In summation, she could argue certain things, but to me, she was just now shifting the burden, saying what they're going to say, and now they've almost made an obligation. I think that's a bad place to start. And remember, mistrials can also come on an accumulation of error by the prosecutor. So right now, I don't know if she got into that great of a start.
Maybe it's close, and maybe, I'm not sure, I don't know the law there, but it might be an issue that needs to be raised at the point in time where the defense attorney should have jumped in and said, objection as to it, because I totally agree with you. But maybe this is just a bundle of sticks that lead towards the mistrial, and they're just kind of collecting them as they go.
Well, you better collect them with the judge. I agree with you, Brian. You better, right then and there, they should have said, I want to be heard at sidebar. And it would have been in good faith, number one, and number two is it would have maybe got it from a 10 to a 7 and toned it down a little bit.
Gotcha. And we're going to continue to follow this case and more, seeing whether or not to be a mistrial at the end of the day after this break. Welcome back. So you see there on the stand, we're listening to the testimony of a co-worker of the grandmother of the decedents, that being the young children. And what I believe we're getting at is, are there any, and at least in New York, we call like outcry, as to testimony as to how the children were raised, the injuries, anything of that nature. Again, coming to you, David, it appears, again, like the prosecution is trying to close off the loops, to say that prior to going to the Rosenbaums, these kids were healthy, prior to this, but I mean, you're the co-worker of the grandmother. How much information, is this a worthwhile witness?
I think you make a great point. And this is, we talked earlier about building a roadmap. On the other hand, this is a scintillating case. You want to catch the jury early on in a case like this because you can. It's not a white-collar case. A bunch of papers is going to put people to sleep. You'd think you want to hook them from the beginning. You may put these witnesses on in the middle if that's part of your theme to show that whatever happened before was relatively normal. These Rosenbaums are monsters. But I think you risk boring the jury and losing them. I don't know. At some point in this case, you're going to get back to really shocking testimony, I assume.
And I kind of agree with David. It feels like I was there for the opening, and I was like, oh, you're screaming. I'm ready. Yeah. I'm there. Then you put on these witnesses, and I was like, so, like, what's the plan here with the prosecutor? Or is there one?
I agree with David. I agree with you. I mean, I don't know if this is really that great, even if you want to be very methodical and go one step at a time, because I'm sitting here wondering, well, if these people are so great, why did the child end up in this dangerous situation, in this dangerous environment? So how credible could these people be in what their story they're saying? I just don't get why they're on there.
Neither do I, and I hope that we do get it eventually. After this break, we're going to come back and continue to cover the Rosenbaum case here at the Law&Crime Trial Network.